Well, hi everyone, and welcome to today's webinar where we're having a look at the 7 must-haves in your SMSF deed. My name is Dunn. I'm the CEO and co-founder of Smarter SMSF, and today we're combining both technical and practical elements to this webinar to help you understand what you need to be looking for within your SMSF deeds, but most importantly, how we have developed our Smarter SMSF deed to be one of the preeminent and most recognized deeds in the marketplace today. So again, we'll kind of go backwards and forwards between the slides and some of the other knowledge-based items and the content that we have in particular around our deed itself. We'll have a discussion about some of the extracts we've got as well. And if you've got questions along the way, I'll be more than happy to have a discussion about those with you as well. So why is it that the deed is so important? Well, in reality, it's all about the fact that the deed acts as the engine for your SMSF client to deal with key decisions, how we manage risk with our clients in the event of things like incapacity, as a good example, and to be able to optimize the strategies in an environment that is ever changing when it comes to superannuation. And we have on our platform, when we see members upgrading clients' trust deeds, I use the word engine there because the first paragraph that we talk about is we use the analogy of a car and the fact that when you buy a car, you don't just continue to drive it. You need to fill it with petrol, it will need servicing, it will need an oil change, it will need all those things to ensure that it runs to its optimal level. And if we don't, then not only will we have problems with it in the future, but it won't avail ourselves to what the latest technology will do and what ultimately we can get out of holding that particular asset. And the self-managed super fund, in my view, is in the very same mold. When we set up that fund, if we go back to clients that maybe 1990s and the early 2000s and so forth, they don't run the same deed. We would have had changes in 2007. We would have had changes hopefully in 2017, and we'll touch on some of that shortly. But we need to continue to run and optimize the way in which the rules of the fund operate to ensure that we can maximize, capitalize, and deal with any risks around the membership and the trusteeship in respect to the fund. So older deeds are likely, therefore, to create problems because of the fact that it will conflict with the current laws and therefore may inhibit the ability for a strategy to occur. And a really good example of that is something like the downsizer contributions. A lot of people would have made those changes in 2017 prior to the new reforms happening there, but the downsizer contributions didn't actually happen until 12 months later. So you would need to ensure that the rules of the fund would accommodate for the fact that a downsizer contribution would be drafted within the deed, is what I'm trying to say, and therefore would allow for that strategy to occur, given it is so heavily utilized within our SMSF client base. We also need to ensure that it allows for certain things to occur, and also, and most importantly here that I talk about a lot, is that we are actually ensuring that the deed that we are using is adequately connected to the company constitution. Still, it is very common that we see the deed upgrade happen, and we may have seen multiple deed upgrades with clients, again, with that self-managed super fund set up in the 90s or 2000s. There's been no change in respect to the constitution. I even saw a memorandum and articles not that long ago with a particular fund. And the fact that as our clients are getting older, it doesn't deal with the succession issues that we need to cover off on. And the constitution here, given the amount of funds that we know have corporate trustees, that constitution is imperative that works hand in glove with the SMSF deed. So I go back to, as one of my first comments here, is you need to ensure that if you do find a fund that has a current deed that predates 30 June 2017, that should be a flag for you that there is deficiencies within that deed that will need to be upgraded to deal with those superannuation reform measures that came in that spoke about the transfer balance cap, that deals with the way in which these must be returned, that deals with areas of death benefits and the differences around how those death benefits must be dealt with and the death benefit income streams that can be paid. They're just some examples there that should be a flag for you again as to what we should be doing there. And then the other two questions that I pose on here is, well, how often should you update a deed? And in some instances, it may be that we'll have clients that we might look to automate that process each and every year. Not that they would necessarily need to have it updated every year, but if you want to offload that responsibility to ensure that it remains current, well, then there are people that do that as a solution. On the flip side, you may be very cognizant of what's going on with all of your particular clients at all points in time, and therefore you will really only need to move the needle on upgrades as and when it falls due. Now, that might be every 3 years, it could be every 5 years, but you need to be very cognizant of what changes are happening and the impact that it has based upon the deed provider that you choose. And ultimately, why is it important to maintain currency of these ongoing changes? Well, I'm about to show you with some of these that are crucial in my view and why you must have them with your current SMSF deeds. So before we jump into each of these areas, I just want to give you a bit of a snapshot of some of these changes that have occurred over the various decades. And you can see here, if we go back to my comment on the previous slide about things post 1 July 2017, there have been a range of things here that, again, justify the fact that anything prior to 30 June 2017 should have a review. But we then go to things like post 2020, and quite clearly here you can see there are a number of other areas that are relevant in the context of why a fund might need to have their rules upgraded, whether it's 4 to 6 members. And it's the prescriptive nature of these things that may influence whether the upgrade must occur or whether we're simply happy to let it run as it is. Quite clearly, there are very few funds that run with 5 and 6 members. So is it actually going to be required to upgrade that deed to allow for that to occur? But there are other elements that do become important. Superstream is one because it's a mandated requirement to deal with not only contributions, but rollovers. Electronic execution, which we'll be talking about today. The changes around work tests, the relief measures that we've seen in respect to COVID over the last few years, and of course, some of our more recent case law in respect to death benefit nominations and the payment of superannuation death benefits. So again, just being conscious of what is going on and why, therefore, in certain situations, it will be important to make that particular deed change. So therefore, let's jump into it in respect to what are the must-haves in my client's SMSF deeds. And I'm going to show you here 7 key areas that we see as very important, and that if you don't have these, well, then you should be considering upgrading, and in particular, why we have them in the Smarter SMSF deed and why it may be opportunistic for you to contemplate using the Smarter SMSF deed going forward if you're not already. So the first one here is around our binding death benefit nominations. And the first must-have is making sure that the binding death benefit instructions that are included within the deed around the operation of binding nominations don't actually import the SIS regulations. Now, what we have seen over the past few years, and this has come out finally as a High Court decision, is that in the Hill and Zuda decision, ultimately we've had confirmed what we have known through different state jurisdictions for some time, that when it comes to self-managed super funds and the operation of binding death benefit nominations, we don't actually have to go to the SIS Act and SIS regulations. So the SIS Act in section 59(1)(a) and then in the regs 6.17(a) set out the requirements that must be adhered to. Now, what has been clear since the ATO actually held this view back in 2008 through an ATO determination is that when we go to looking at how a binding nomination can be prepared and the validity of that nomination, well, what we need to do is go to the rules of the fund. And we must explicitly follow what the rules of the fund actually say we must do. So you must be very clear around the procedure. And this is where a lot of these cases come about. Not so much that the document hasn't been witnessed by parties that haven't listed a cis-dependent beneficiary, but it's the procedural aspects that must have occurred. The fact that there needs to be acceptance. So is there a trustee minute that is followed that says the trustee is going to accept that amount, that nomination, I should say? Or does it need to be accepted by one party or multiple parties? Does it need to be served upon the trustee? And what does the serving mean? Where does it need to be served? Does it need to be served on both of those individuals? So the very specifics and nuances of that deed become absolutely crucial. But what we have seen over time, and it's quite common that we do see this within various deeds, is that we have the fact that the requirements of the regulations in essence get imported back into the deed. So the deed says, in this instance, if we look at Donovan and Donovan, is that the deed says that the BDBN must meet the statutory requirements. So when we go to what the definition of the statutory requirements means, well, in essence, it's referring us straight back to SIS Regulation 6.17a. So they have imported, in essence, what the ATO and various references in case law have said you don't need to actually reference. So again, go back and be very clear on the fact that the BDBNs are abundantly clear that what is in your deed is what must be followed. And then on the basis that there is a process that must be followed within the deed, that you are explicitly following those particular requirements. So when it comes to the Smarter SMSF deed, we have it in our Rule 11, the ability to do various combinations or various options in respect to binding death benefit nominations, whether they are lapsing or non-lapsing, whether you want to create a standard or non-binding nomination, and also the ability to create an SMSF will. Now, you can see here on the left-hand side, this is an extract of Rule 11, but it's very clear in here that it says if you are going to prepare a binding death benefit nomination, that it must follow the format that is set out within Appendix 2 of the document. So the deed provides an example of that binding death benefit nomination. So the form and substance in which that nomination has been provided in Appendix 2 is the way in which a binding death benefit nomination must be completed by that individual, and then ultimately that would be served upon the trustees to ensure that it is valid. Now, when it comes to the validity, then we need to go to a Rule 11.2, which sets out the time frame in which that can be served upon the trustees for it to be valid. And this is one of the changes that we made from the 1st of July 2023, that not only can it be produced at any time prior to that individual having passed away, but where there may be concerns that the decisions of this nomination might blow up a particular relationship, well, then there is scope for that nomination to be served on the trustees potentially as much as 6 months after the individual's date of death. Now, we are very clear around that time frame, and the reason why that time frame is imposed is because we can't just have that remaining loose because the death benefit ultimately needs to be dealt with as soon as practicable. So the time frames there are also noted within the binding death benefit nomination document to ensure that when they're completing that nomination, that ultimately they are acknowledging that if it's being kept in the drawer and to be served after they're no longer here by maybe their representative, legal representative, or the solicitor, or whoever it is, that there is a prescribed time frame, or otherwise, ultimately, that is an invalid and will be treated as an invalid nomination. And finally here, we make very clear around the restrictions that are imposed as to who can make the nomination for the benefit of the member. So there's no ability for the amendment to be made or for the nomination to be made by someone representing that individual. It must be done by the individuals in their own right. Now, the other parts to this is in respect to our Rule 11.5, and this is all about describing the manner and form in which the death benefit will be paid based upon the direction that has been provided. So again, here, any of the documents that we referred to in Rule 11.1, which is the different formats that you have here, then what we look at here is it provides us with the opportunity to determine within that nomination how we want something to be paid. So is it simply based upon a relevant percentage for that individual? Is it based upon a type of death benefit that it's going to be done? So the form, so i.e., is it a lump sum? Is it a pension? Is it any combination of those two? If we're going to be leaving a level of discretion, then is that discretion going to be invoked in here by percentage terms? Is it going to be recognised by dollar amounts? Do we want to have any sort of cascading beneficiaries? These are all things that you can build into the nomination documents that we have on the Smarter SMSF platform as well. So you can see all of those elements there that are crucial in the way in which that death benefit nomination would be constructed. But most importantly, I go back to that first must-have, is ensuring that it is being abundantly clear that we are following the rules of the fund. And insofar that the rules of the fund are concerned, they are not importing the regulations which are specifically excluded when we look at the court decisions and also the views that the ATO have expressed since 2008 through that SMSFD 2008/3. So the other couple of things here, just to finish off in terms of this Rule 11, we did a bit of work to this from the 1st of July 2023. It just confirms that under Rule 11.7 here, it binds the trustee in respect to that direction once it's been received and they recognise that it is a valid nomination. And then finally, we go down to 11.8 and just recognises the fact that if we have a situation where the nomination that has been put forward does not actually pay it or direct it to be paid to a CIS dependent, then in essence, there is no instruction that the trustee is bound by in respect to that decision. So therefore, we need to make sure that that the member is effectively nominating someone who is a CIS dependent. Otherwise, the default position will be that the trustee will direct that payment to the legal personal representative of that individual. So let's now move on to our second must-have. And this is, in my view, something that we have that is unique to our Smarter SMSF deed, and that is the ability to create special rules within the fund. So when we think about an SMSF trust deed, the deed will generally outline all the different rules around membership, around trustee powers, about creating different interests within the fund, the way in which contributions can be made and paying benefits and so forth. And when we think about the way in which an SMSF deed is going to be crafted, well, the reality is that we want to ensure that it's not being drafted in a way that is too prescriptive. And what I mean by that is you don't want a situation whereby the way in which it's drafted is that every time there is a change that occurs, you need to go back and make another amendment. So a really good example of this is where the number of members moved from 4 to 6. So is there something within the deed that limits membership to 4? Rather than saying, well, is membership limited by what the laws allow within the CIS Act or CIS regulation, however that's ultimately prescribed. So, and that's one of the reasons why we use the concept of an authorised contribution. So contribution in accordance with the superannuation laws, and there's a definition around the superannuation laws that encapsulates the income tax laws, et cetera, et cetera. So you want something to be loose enough that covers the situations, but not so loose that really, the value of what the deed is meant to do is somewhat obsolete. But in saying all that, the other part is then that we have these different fund and or member events that will occur that is going to effectively need a little bit more meat on the bone. And what I mean by that is that we'll need to have other documents prepared. And when those documents are prepared, in reality, it would be great if they could be annexed to the fund's deed as if it was forming part of the deed itself. Because of the fact that we have a less prescriptive deed, the ability, i.e., to pay an income stream in accordance with the superannuation laws is great for the purposes of the deed to be able to pay a pension. But the operation of that pension, we need to be more specific within the drafting of the documents around that pension commencement. So therefore, if we could annex those pension documents as a contractual arrangement between the trustee and the member, then that would be a fantastic outcome. And there is born ultimately the ability to create a special rule of the fund. So when it comes to the Smarter SMSF deed, you can see here by definition that the special rule of the fund is created by a trustee meeting that forms part of the rules of the fund and is declared by the trustee to be a special rule. So pursuant to Rule 8, which you can see down below, the special rule cannot be varied without the specific consent of the trustee and where the applicable member is concerned. So that's really important here. So it's a contractual arrangement ultimately that we have between the trustee and member. So pension documents, when we talk on the ability to change a pension midstream, the concept of the special rule is abundantly important here, because what it does is it says, well, we have effectively made these pension documents a rule that sits inside the trust deed. And the ability to change one of those conditions, as long as it's done between the relevant parties, i.e. it's done between the trustee and the member, then that is an acceptable form of doing so without actually going through a full commutation and then repurchase and the impacts that that might have. So Rule 1.8 here talks about the fact that the trustee here may create an additional rule of the fund where authorised under the rules of the fund to create for reserves, living wills, SMSF wills, or member pensions. Any additional rule that is in essence created becomes a special rule on the basis that we declare as the trustee that such may occur and may not be varied by any variation of these rules unless with the specific consent of both parties involved. So the concept of a special rule here goes across a number of areas within the Smarter SMSF deed. So it's in respect to the creation of what we have as our living will. So this is the SMSF living will, in essence, deals with things like what happens in the event of incapacity in respect to particular members. But it also deals on the flip side around death benefits. So we look at death benefit nominations and SMSF wills. The concept, I should say, of superannuation income streams. So account-based pensions, death benefit pensions, conditional pensions with blended families. All of these types of documents can become special rules of the fund. Equally, at a fund level, we can look at it in the context of reserve accounts or appointments of fund guardians, where that would be appropriate as well. And then income streams, as I touched on earlier, is probably the key area and the most important one that we see on a day-to-day basis with the orders that happen on the Smarter SMSF platform. And you can see here Rule 25.2 talks about the fact that where a trustee commences a pension for a member or for the dependent or for the LPR or deceased, the terms of that income stream, including things such as whether it's auto-reversionary and to whom it shall be automatically to be paid to, can be determined to be a special rule of the fund, okay? And then it allows for things, as it says in B, to be able to add or remove where it would be warranted to ultimately do so. And this is where, if I jump over to our knowledge base and I look at the pension commencement documentation that you can see here, one of the things that is being ultimately put in place by the trustee as part of this process is that we have the powers to be able to pay the pension, but we also then note that the terms and conditions of the income stream, including whether it's auto-reversionary, is to be a paramount document and also to become a special rule of the fund. So there's been the declaration of that by the trustee, and then ultimately there is the acceptance of it as the member that follows underneath here as well. Okay, so a few of these are really important steps for you to understand as to why we see the concept of the special rule being integral to the overall operation of the fund. Now, one of the questions that we do get quite regularly is when people upgrade to the Smarter SMSF deed, they say, well, we might already have some documents in place here. So can we maybe create a special rule of the fund with these? Well, yes, you can. But what it would require you to do is to effectively make a decision once the deed has been updated to make that particular thing, like pension documents, a special rule of the fund. So there is an ability within our platform to elect for certain things that may have already been done in the past to become a special rule, as long as it allows for it to occur under the deed, and pensions, as you can see here, is a really good example. Now, the other thing I did mention as I was reading out that from the pension documents is the concept of a paramount document. So again, one of the other unique features within the Smarter SMSF document suite and within the deed is that you can choose to have the terms of the pension here, and this equally applies with other documents, as a paramount document. And in essence, what this gives you is a neutrality to say, do I want this document in the event of any conflict to outrank any other document that may be in conflict with this particular document? So the common one here is when we think about the payment of a pension, a document that may be in conflict could be a binding death benefit nomination. So one of those documents, if it is deemed to be the paramount document, well then, in essence, the pension document, if it's elected to be the paramount document and it did include a reversionary, for example, well then the trustees will be bound by that decision for that pension to auto-revert. Okay, so again, these are some things that are quite unique to the way in which we've drafted them. Very specific, of course, to the knowledge that we have around these particular issues, rather than you getting forced down a particular route that may not be the right outcome for your clients. Now, the next one here is around the areas of succession. And the next two actually will somewhat deal with this particular area, and it's becoming an even more important area of focus with our SMSF clients because, as we know, whilst there's new entrants getting younger and younger, we have a much older demographic that are now starting to shape our SMSF client base, and therefore the risks of things like incapacity become a much more real and tangible scenario. We can see this because we can see the change that is happening in the types of documents that are being ordered on our site, the fact that we're removing individuals as trustees when it comes to incapacity or in the event of death, or we can see changes through the directorship, so the documentation that links to the Constitution. So understanding the definitions here are crucial to what has to happen and what you may want to happen as well. So they've got a distinction here between, well, what may happen, but what do we actually want to have happen? Okay, and this is where the definitions in respect to legal disability and death are quite important. So we have within our SMSF definition in 17A3B, the requirements that must be met where a member is under a legal disability. Okay, so in essence, they've lost capacity, they may be overseas. So there's a whole range of things that we need to deal with whereby the person representing them would hold an enduring power of attorney to step into their shoes because of that legal disability. But equally, we could have a scenario whereby a person holds the LPR, the member may still have their faculties to be able to make decisions, but they don't want to, in essence, are going to hand that over to someone that holds an enduring power of attorney. So that equally can apply. And then on the flip side, in respect to the member's death, we have within 17A3A, when a member dies, we have the ability to appoint the legal representative of that individual. But it's not a mandatory function. I'm going to come back to that in a second. So what's really important here is that you understand what the member wants in respect to events that occur around incapacity or when they die. And therefore, are you confident that the current documents that you have will allow for these sequence of events to occur? In some instances, you want this to occur automatically. Okay, so it's having some sort of successor provisions in place that will be able to step you through that process, and that you've got the right people in place that will be able to accept that appointment and, in essence, continue the operation of the fund or deal with the payment of the superannuation death benefits. So I pulled out two specific areas here within the Smarter SMSF deed. So the first is in respect to 2.10 here around trusteeship and membership. So one here is in respect to incapacity. So when the member becomes incompetent and loses legal capacity, is no longer able to function, then the LPR here is to be appointed as a replacement trustee as long as it's permitted under the constitution of the corporate trustee. So it's absolutely crucial here that we have alignment between the trustee company rules and the governing fund, the governing rules of the fund. And this is where I go back to that original comment that I made on my first slide around the fact that too often we see multiple changes going through on deed upgrades, but we haven't seen any change in respect to the constitution. So they're not working together, and there's a real disconnect between what the two are doing. And therefore, when you're trying to get the right outcome, things are tripping over fairly rapidly for you. And really, the only one to blame is you as the professional, because these things should have been looked at along the way. And then when we get to the death of a member, it's the time frame that we have there from the member's death to look at the appointment of that legal representative or a party nominated by the member, maybe under a nomination or their SMSF will, and then upon their consent, look to be appointed. And I go back to the comment that I made on the previous slide that I was going to refer to here. When we look at the definition of a self-managed super fund around when a member dies, it's permissive to be able to appoint someone to represent them. But it's not a mandatory function. And we saw this in the WA case of Iopolo and Conti, where in essence, there was no mandated requirement in the individual trustees to bring in the legal personal representatives. And what we saw in that case was effectively the husband changed the trustee of the fund because he didn't want to have the daughters-in-law, in essence, coming into the fund and sticking their nose in, because he clearly wanted to have the benefits paid to himself as the dependent, rather than the daughters coming in and then ultimately trying to look to pay it to the legal personal representative. And he was found to have done the right thing. So because, again, it comes back to this definition that says, well, you don't actually have to appoint someone else. You've got your time frame that you must have within 6 months that you end up with a complying fund from the definition point of view under Section 17A, but there's no mandated requirement to do it. This is where, again, within our SMSF documentation, and in particular, the binding death benefit nomination, you have that ability to bring in the replacement trustee if you want to. So as part of the binding death benefit nomination, there is a section that specifically sets out the ability for you to say, well, in the event of my death, I hereby choose to actually bring this person into that particular role. And what I might do is I might jump down to the Smarter SMSF deed here and take you to the appendix that I was talking about before. Because what we have here with the binding death benefit nomination, as you can see, is effectively we have this requirement around whether it's to be lapsing or non-lapsing. And then we have the requirements of the cascading nominations and so forth as well. But then we have the opportunity here to nominate the replacement trustee. So in this instance here, I wish to nominate, insert individual as my replacement trustee or director of the corporate trustee, or you can make that decision to effectively not introduce someone and leave it to the discretion of the other party there to ultimately deal with the benefits that may be. And that's probably a more common situation in maybe a husband and wife, as may be the case. But you're looking specifically there at the ability to bring someone else in. So that's mandating that requirement for the purposes of running this fund, because here we've nominated by the member through the nomination to bring that person in to act as the replacement trustee. So really crucial that, again, you understand the nuances of what can occur and the nuances of what the actual individual wants. And I go back to this slide here, understanding what the member wants in respect to incapacity or in the event of death, and making sure you've got the documents in place that will enable them to do that. So the other part to this is whether your existing deed allows for the appointment of what we call a fund member's guardian. So here, when we look at the context or concept of a guardian, we know that we might appoint, when we think of enduring powers of attorney and so forth, that we'll appoint people that are probably family members, it might be kids and so forth, but when it comes to money, it can be somewhat challenging. You might have different levels of literacy amongst kids. You might have some kids that have more financial strain and therefore have much higher demands in respect to the way decisions are going to be made. The problem with that is that that can potentially lead on to risks, and risks that have been identified by governments, such as elder abuse. But when it comes to, well, who as the trusted advisor, can you be as appointed as the trusted advisor, maybe into the role as the EPA? We then have issues around, well, we have our Section 17 definition. You can't ultimately be paid for that work that needs to be done. There may also be some code of conduct restrictions on you being able to undertake that certain role as well. So dealing with succession here and ensuring that you've got the right people on the bus who are adequately skilled to do that role can become somewhat challenging. And this is where we've developed what we call the fund member's guardian. So do you want to create decision-making powers for certain individuals, or do you want someone simply to have the oversight as the trusted advisor? And that's in essence what we've done here with the fund member's guardian, is that you're not putting all the decisions that an enduring power of attorney might do in the hands of the guardian, but the guardian is there in essence to have oversight, to make sure that the kids or one child, whatever it may be, a sister, a brother, an uncle, an aunt, whoever's in that role, ultimately will do what you wished was to have happen. And therefore, the guardian's role here can set about the various powers, functions, and restrictions that the member may wish to impose around that appointment. The most important thing from a Section 17 requirement, 17A requirement, is it sits outside the definition of an SMSF. So it does therefore allow for a professional advisor to sit in that role to act as the member's guardian. So it is created by a deed of appointment to specify what those powers and functions are, but ultimately the role here is providing veto powers. So there will be certain circumstances where the trustee, in making a particular decision, i.e. to commute the pension, where that person may be incapacitated, that they need to actually go, well, yeah, we're simply going to commute the pension. Well, no, you can't do that unless the guardian themselves also permit for that to occur. So there's that oversight, as I've touched on, that allow for control of the events to occur, that the guardian will have a better understanding, you being in that trusted relationship with that client for many, many years, so you know what the wishes of that individual are. Now, the commutation of the pension may be the right thing. They may be moving into much higher care, and therefore it's simply just an extra belt and braces that needs to occur to allow that to ultimately happen. But it is an important step and a tool that we see commonly used now that allows for a professional to step into that particular role. So you can see here, we have our deed of appointment, and it is effectively a deed that sets out all of the different permissions, who that person is, what role they're undertaking, what the terms of the appointment are, how the appointment can be revoked, and so on and so forth. So I've got a link that I've included in the slides here that you'll get after today's session, and it will help you to understand why the Guardian is an important tool. Like I said, it doesn't necessarily mean that it'll be used every time, but it's something there that we see as a really important tool to actually help manage as clients get older and they don't necessarily have all the skills to, and neither are they represented within the family to ensure that the right things will be done. It's just a very good protection mechanism that we see within our deed to actually help facilitate that. So the layers of protection here, so our Rule 26 covers this, allows for the members' wishes in respect to their benefits being adhered to. So therefore, the trustee cannot do something, cannot exercise the power that is conferred upon them as trustee without the guardian's prior written consent. Okay, so that's the important bit. And then finally, as we spoke about before, it's around the revocation of that role. So again, it's important in setting out when the guardian's role will cease and who ultimately has the power to revoke that role. So again, making sure all those loose ends are ultimately tidied up as well. So let's keep moving. We're up to our fifth one now in terms of the 7 must-haves in an SMSF deed. And that is understanding how documents can be signed and meetings held in today's environment. Now, COVID quite clearly has transformed the way in which we deal with electronic communications and its utilization in everyday life. And this certainly is also represented within SMSFs and in your role as a practitioner in day-to-day as well. But when it comes to self-managed super funds, understanding how electronic signing is allowed to be used is important because it's still not accepted practice in all of the various circumstances. And I'm not only talking about technical here and in a legislative sense, I'm also talking about practically. So what a policy might look like within a bank to enable for a bank account to be opened, for a loan to be granted, whatever the case may be, okay, for a title to be issued. So understanding the differences in a legislative point between what the Corporations Act allows for, what the SIS Act allows for, and then what you can and can't do within the SMSF deed itself. So one of the more recent challenges is whether your deed contemplates how certain documents can be executed in a technology neutral way. So this is something that we made a very specific change to from the 1st of July, 2023. So where something is to be signed ultimately by the trustees of the fund or by the members of the fund, it can now be done in a technology neutral way. So we've introduced a Rule 30 that you can see here, subject to the superannuation laws, which is a definition. This deed or any document required to be signed pursuant to the deed may be signed by either a physical form of the document by hand or by signing an electronic form of the document using electronic means. So we're being very specific here that gives us that technology neutrality to dealing with the execution of documents. And by having this added into the Smarter SMSF deed, it now allows for any of the items that can be paid under the deed to be done in either form. So if you're using digital signing technology and you want to send the clients the documents to sign the pension, or they're setting up a brand new fund, and yes, you can have the Constitution and the deed signed in respect to Section 127(1) of the Corporations Act. Well, the member applications, they can be signed because the powers within the deed allow for those applications to be signed in a technology neutral way. Now, there are some challenges when it comes to the establishment of the fund because Section 104A in respect to trustee declarations, that is something that cannot currently be signed in a electronic means because the Electronic Transactions Act specifically has the SIS Act excluded from being able to apply the Electronic Transactions Act provisions. So again, there are nuances to this, but when it comes to any decisions or any events that occur within the deed itself, so a pension is a really good example here because we're not only looking at elements of paying pensions within the SIS Act and regulations, and then we have considerations within the Income Tax Assessment Act around transfer balance cap and ECPI and so forth. But when it comes to paying the pension is provided for by the governing rules of the fund. So the documents to enable the pension to be paid, if you're going to sign those electronically, you must have the relevant provisions within the SMSF deed to allow for electronic execution. And if not, then if you have utilized electronic execution, it does put into question whether those documents have been validly executed or not. And therefore, if there is going to be any challenge in the future around the payment, maybe it's the auto reversion of that pension or not, expect a challenge in court at some point in the future in respect to this sort of work. And we did see a case in Victoria not that long ago called Re Curtis, not in respect to SMSFs, but in respect to the validity of a will and the witnessing requirements. And it was found because the witness, you didn't cite the witnessing of that document on the screen, on the Zoom screen, ultimately that will was found to be invalid because of the fact that it didn't comply very specifically with the witnessing requirements here in Victoria where it is being done using electronic means. So the courts will apply very technically what the rules of the fund say and how it needs to be looked at in accordance with the relevant laws as well. So we've seen it with binding death benefit nominations in respect to the way in which the courts look at the construct of the deed. And here's yet another example that we will see tested at some point, mark my words. So the other two that we're going to wrap up with today, our sixth one is decision-making and dealing with disputes. Okay, so decision-making is really important and really goes to the succession stuff that we'll talk about before, but goes to the, all the D's that we have around dispute and death and disability and divorce and so on and so forth. So being very clear on understanding how decision-making is undertaken within the fund, right? And it's not just decision-making within the fund itself, but it's the corporate trustee that exists, i.e. going back to that constitution. So who is it that needs to make the decision? Is it the trustee? Is it the member? Or is it both? And how is the decision to be determined? So does it require a meeting? Or does it need a quorum of, say, 50%? And once we have that quorum, how are votes determined for a resolution to be passed? Now, this kind of seems somewhat trivial, but I can tell you more and more and more often we're needing to ensure that the right process is being done in respect to different events that are occurring within our SMSFs. So the votes then for determining for a resolution to be passed, we then go to either the constitution or deed to look at this based upon whether it's a trustee decision or a member decision. So is it simply one vote per trustee or member? Or is the voting based upon the dollar of account balance that the individuals have? So i.e. you get one vote per $1 of account balance that you hold. So you could have a trustee, you might even have 6 members, but one member has, say, $2 million in the fund, and the accumulated value of the other 5 might be $1.5 million. Well, ultimately, that one person rules the fund and the key decisions that can be made. But we also could have circumstances whereby there is a one-for-one decision-making process, but then in the event of deadlock, there may be a different mechanism to ensure that we get a decision. But what happens if we get into this dispute, and therefore how do we then mediate that particular process? Because there's no real way to go like you can with a APRA regulated fund to go and seek some form of mediation to get a particular outcome for your clients. One of the things that we've done within our Smarter SMSF deed is to look at the way in terms of how meetings are not only held here, which is pretty standard in terms of deeds. So it's the obligations, of course, in respect to dealing with meetings and who needs to do that in respect to decisions of maybe making changes to trustees in the fund. We have timing around how many, what the quorum is and how voting in this instance is done, which in the Smarter SMSF deed is based upon dollar of account balance as opposed to a one-to-one voting right. We also accommodate for the fact that meetings can be held in a technology neutral manner for members to be able to cast a vote, or whether it's done by circulating minute, and the fact that it just requires a simple majority for that to occur. One of the things that we're continuing to look at is the ability to potentially look at a deed of key decisions. So the fact that over time that bar for decisions to be made may be higher based upon particular events occurring. So if we go back to things like incapacity, so that therefore the others involved, where one person now may be acting as a representative and might hold a controlling interest in decision making. Well, rather than it being a 50% number, it may be unanimous, or it may be a higher figure like 75% as an example. So again, there's a lot more decision making around the documents and the way in which the fund is going to run going forward that becomes crucial to this overall process. And then I come to the dispute resolution here as well. And this is something, again, that's relatively unique to what we've done within the Smarter SMSF deed. And we've had discussions with the SMSF Association about this, who've been more than accommodating to try and look at getting a resolution. So before we ultimately have legal action taken by disputing parties, we try and create a remediation process. So a mechanism here to try and help resolve the dispute before it goes into what would be a very long, lengthy, and expensive process, okay? And ultimately, we look to the peak body in the SMSF industry, being the SMSF Association, to find a mediator. So the mediator is someone that would have the requisite skills in that particular area of dispute. Could be death, it could be in respect to incapacity, it could be in respect to family law. There's a whole range of areas where, ultimately through that membership, there would be an opportunity for the relevant officer of the SMSF Association to look to have someone appointed with that requisite knowledge, either internally at the association or externally to a point, to try and help get some resolution to that situation. And on the basis that there is no resolution, then ultimately those next steps could occur. But it's a mechanism that really doesn't exist within the SMSF landscape ordinarily. So we've provided that opportunity to try and find a mediated outcome, save a bit of time, effort, and money for all involved. If it can be achieved, if it can't, then ultimately those next steps would need to be applied. So you can see there under 27.3, if a requirement the disputing party must, before instituting any legal proceedings in respect of the dispute, and then complete that process as described in Rule 27. So it's kind of a bridging point that we've built into this process. So again, that we don't end up in what could be a quite lengthy final process to try and get that dispute resolved in whatever case it may be. And the final one here is in respect to the decisions or the way in which trustees are empowered to do certain things. And what many people don't understand is that there are a range of popular activities that are prohibited from being able to occur by virtue of the legislation, unless there is an express power within the deed for that to actually occur. So for example, we have general prohibitions within the fund to carry on a business, e.g., so property development, unless we have the ability to allow for that to occur, expressly provided for in the deed, or the fact that trustees can be remunerated for their services, or they can invest in non-income producing assets, or alternatively invest in single bulky assets without diversification. So all these things that somewhat sit in covenants and other elements of definitions within the SIS Act and regulations, we need to ensure that we have an express power inserted in the deed that says that we can do those things. So we're not prohibited from doing so. And therefore, on the basis that we do that, it's crucial that the governing rules empower such activities to occur, along with many more of the commercially realistic ventures that might happen as well. So here, when we look at the trustee powers, within the deed, what you're looking for is those specific powers, as we've got in Rule 15 here, that are conferred upon the trustee to undertake those activities or be able to deal with those transactions or arrangements, whilst ensuring that the fund will remain a complying SMSF. Okay, so Rule 15 here, the trustee has unlimited powers as to the administration and control of the assets of the fund. The admin and control of the assets are identical to those as if the trustee were the legal and beneficial owner of those assets, include the right to sell, call in, convert, grant, etc., etc. Okay, and when we go through, there are a range of powers that we have listed, and then we have some additional powers that we have in here, going back to that comment that I made around some general prohibitions that exist. So here we have real property, for example, where you have the ability to purchase, take on, lease, license, develop, construct, hold, impose, sell, etc., etc. We can also undertake assets for no profit, so without limitation to the above, to exercise any of its powers, including the power to sell, the power to deal with real or personal, whether at profit or not. Okay, so the fact that the asset is held without potentially having to generate income, which would be part of, in essence, the investment strategy covenant. And then the ability to carry on a business. So again, subject to the rules of the superannuation laws, and the fund retaining its complying status can carry on a business to undertake business-like activities. Now that doesn't mean that we can just carry on a business and breach sole purpose and those sorts of things, because of course the covenants override in essence what is in the deed and making sure that we do that. But there will be activities that are business-like activities, and property development is a really good point there, that allow us to do it. But as long as we adhere to sole purpose, as long as we adhere to related party acquisition rules, as long as we adhere to in-house asset rules, all of those things would be fine to be able to carry on and conduct a business-like activity within the fund without actually breaching any of those provisions that I just mentioned. So having express powers there are absolutely crucial within your deed to enable those things to occur. So is there anything else that I should be considering? So from my point of view, changes to legislation do not automatically result in a deed needing to be amended. Okay, so that's the first thing. So what you're doing is making sure you're looking for prescriptive references within the deed that may be impacted by law changes. And I've used this example already around the 4 to 6. Equally, things like downsizer contributions, where we've seen age changes drop down from 65 to 55 over the past 18 months or so. So the other thing you could be asking is, does the member need to make any changes as a result of the different legislative change? And for me, on the right-hand side here, I've used this in a couple of other webinars, the fact that when you're looking at deed providers, it's understanding the level of depth and knowledge and specialization that sit within that particular provider. So are you looking at providers that are really depth of content or breadth of documents that are available? And it's that extended thinking that we have at Smarter SMSF, where we look at the deed and we ensure it will tick all the boxes from a SIS and tax perspective. But it's far more strategy focused, okay? And there are tools in there then that we have, like special rules and paramount documents and those sort of things, that allow us to go deeper in terms of strategy, risk management, than what many of our competitors would ultimately try to hang their hat on. So a regular review in this instance is a crucial step as part of your standard business practice. What that looks like and how often is somewhat up to you. But if you're sort of now 5, 6, 7 years in from the last deed upgrades, today I've highlighted for you just a few things that you should start to be considering if you don't already have these inside your deed. And also looking at what's on the horizon, because we know there's Division 296 tax as well. And yes, there will be some changes that will need to come in to reflect what those laws will ultimately look like, in particular about the release of payments and how that mechanisms and so forth will work. So about our deed, Smarter SMSF, I guess, importantly owns all the deed document and legal IP around the deed. Okay, so Ian Glenister, who helped develop that, was a practicing Australian legal practitioner, is a shareholder in the business. It was his IP. The Smarter SMSF business has acquired all that IP off him. And then what we do is we continue to have that documentation reviewed by legal practitioners. So we have appointed Hill Legal to help undertake that work for us. So right across the suite of documents that we have with our new SMSFs and our deed upgrades and our LRBAs and all those sorts of things, they all go through a fairly robust process of legal sign-off. When it comes to the features, again, I've highlighted many of these different things today for you as some of the must-haves that you should have, and as to why we see our deed as one of the leading providers in the industry, and why we've been a finalist many times in respect to various SMSF awards in the SMSF document provider space. And the other thing is that, if you are looking at deed upgrades, well, one of the common things that people look to do as a project is look to document subscriptions. Now, we've just held a webinar around the benefits of a document subscription. So if you want to find out more about that, we've now uploaded that onto our YouTube channel. When you download these slides and we send them through to you, you can go onto the YouTube channel and you can find out more a bit about that as well. We will be uploading this webinar as well onto our YouTube channel if you want to go back and have a look at some of these must-have areas in more detail as well. And the final one here, from a bit of an FAQs point of view, in terms of where can you find a sample of the current Smarter SMSF deed, well, we do have our knowledge base, so you can go on and have a look at the the copy of that deed, what it looks like, the provisions and so forth there. In terms of the legal review, we've touched on that already on our previous slide there. In terms of legal sign-off, so if you're going through a deed upgrade process and you want to have that process effectively legally signed off as part of the ordering of the deed upgrades, we now have our legal review service. So you can tap into that legal review to enable you to access. So if I go to Smarter SMSF website, we now have our legal review service that enables you to access the level of legal support. So you can have a scope review or comprehensive review to make sure that the trail of documents in respect to that review ultimately have been vetted by a practicing solicitor and has got a legal certification that sits behind that as well. Now, the pricing points here, without going through too much detail, is in essence the number of documents as part of that chain. If you want to, again, find out more, Chris Hill and myself ran a webinar not that long ago, and you can come onto this page and have a look and find out a bit more about that particular service as well. So the other few questions, I guess, in terms of wrapping up here, in terms of how often the deed is updated, ultimately we're guided by legislative change and case law and so forth, but you will be seeing changes at least once a year, most likely. Naturally, we've got PDSs and other things to be updating as well. And we do have a full change log. So you can go on to the knowledge base and get access to that and see what changes have gone through and why, importantly, we've made those changes. And if you have clients that maybe have missing documents or documents that maybe need some form of rectification, again, that legal review service enables you to undertake those reviews and ensure that they are remedied as and when they need to be. How do we deal with additional parties? Well, these sort of things we can obviously fix or add into the existing documents that we have there. Our deed upgrade form allows you to add different legal additional parties to it, whether it be founder, participating employer, employer sponsor, those sort of things as well. We've touched on the recommending, the updating, the timing and so forth, but equally, as I said at the earlier stage today, we do have an automated deed update service we'll be shortly releasing. We're in the final stages of testing with that. So if you want to, in essence, hand over some of that responsibility that each time Smarter SMSF does that deed upgrade, that the fund will automatically upgrade to those current rules, then that deed service may be something for you to consider that does also fit within our document package subscriptions, so that it's not a separate pack. You can, in essence, just buy your bundles to not only order documents, whether it be deed upgrades and so forth, but you can use that same subscription package to each year have deducted off the counter the number of funds that you have through that automated deed service as well. So that pretty much takes us to the end of today. Thank you once again for joining me around what is our 7 must-haves within your SMSF deed. Hopefully I've shown you what the benefits of our Smarter SMSF deed are about as part of that particular process and why we see it as crucial that these sort of things are covered off within your SMSF deed for your clients. We do have a number of sessions coming up that you can see on the screen here, including our upcoming online SMSF masterclass, where we are looking at property and LRBAs. And the other thing that is worth noting there is later in June, we will be running our Smarter Integrations Week, where we'll be showcasing all of our integrations with BGL, Class, Supermate, and also with our fund establishment process around the ABN and company integrations. You can find out more by going to our events page. But thank you once again for joining us. As you can see there, we do believe that we work smarter together, which is why what we do at Smarter SMSF is all about helping you to do what you do best with your clients. Thank you once again for joining me for today's session. If you do have any other questions, please feel free to get in contact with me. Otherwise, have a great rest of the day and bye for now.